So first and foremost, in regards to your ex's stimulus check, let's start there. I just had this question come up the other day. Hey, I'm getting my ex's stimulus check in my bank account. Can I keep it? No, it is their money. You are divorced, but a lot of times when this is
Alex here with a Perspectives video on COVID-19 and child custody. We are here with certified family law specialist Andriea Aden, remote from her office in Reno. Let's go straight into it. Why don't you start off with letting us know a little bit about you and what your firm does?
Sure. As you said, my name is Andrea Aden. I am a family law attorney here in Reno, Nevada. I'm also a certified family law specialist through the State Bar of Nevada. So I have my own law firm here where I exclusively practice family law, anything in that area. I have another associate that works here with me, as well as a full-time paralegal and a legal assistant.
A little bit of a bonus question because people have asked me about this, but what is the distinction between being a certified family law specialist and just sort of claiming that you sort of practice a specific area? Because what I've heard is it's a pretty rigorous standard to obtain that certification.
Sure. So to claim or be able to say you are a certified family law specialist through the State Bar of Nevada, you have to first meet certain requirements in order to even sit for the exam, of which there are numerous requirements. You've had to have practiced family law for so many years, you've had to have litigated so many cases, have had so many continuing education credits, and things of that nature. You then apply to sit for the Certified Family Law Specialist exam, which consists of 100 multiple choice questions, which is not a simple A, B, C, D. It's paragraphs. Each question is about a page. You have 3 hours to complete the exam, and then you have to pass the exam, missing no less. And I believe when I took it a few years ago, it was no less than like 15 questions out of 100. So you have to get at least a B to be able to pass. It was hard. I studied every night for about 2 to 3 months.
I really appreciate you answering that because so many people don't understand that it's not just something that you can claim you are as an attorney. It takes a lot of work. And so it was great that you underlined that. So let's go into, I guess, the main topic here, and that is coronavirus and child custody. The plethora of questions involve denial of access to the children, and most of the time it's unilateral. But hopefully, when you go into your answer or explanation as to what you think about this issue, you can cover both the people who are actually asking the court to do this and then the other people who are just kind of doing it and just seeing if they can get away with it.
Sure. When the biggest issue when the shelter in place orders came down, especially in Nevada, was what do we do? I mean, I was getting bombarded by clients. Do we still have to do custodial exchanges? Can I keep my kids? And then, even more so, was travel across state lines. So we have summer coming up, and a lot of parents that live out of state have custody for the summer, and parents were really just at a loss on what to do first with the custodial exchanges. And then the new issue has been those that are essential workers that are being exposed potentially on a daily basis, and the other parents wanting to not have that parent around the children. There's no clear definitive answer, to be honest. I've seen states do varying different things. I saw one case where a mother who was a doctor completely lost custody of her child. I have not seen that in Nevada. What I've been advising my clients is a court order is a court order, meaning you need to comply. The custodial exchanges go as planned. And unless you can provide information that your children really are in imminent harm or danger, that's our standard here in Nevada for an ex parte motion regarding custody or visitation to change that on an emergency basis. Unless you can meet that standard, it's going to be status quo. I've had a lot of clients really concerned about their children even being at the other parent's house and having people around them and having sleepovers or being around friends or other people. And it's opened a whole different world of one parent wanting to control or have input on what's going on in the other parent's home. And until I can prove that that child really is in danger, the court order is going to control. And I've seen that consistently from the courts as well.
That's a very three-dimensional answer. It's really appreciated. Do you think that part of, I don't want to use the word problem because it has a pejorative connotation, but do you think part of what factors into why it's really hard to be certain what a position a particular department in one of our judicial districts is going to take has to do with the discretion or the wide latitude afforded to family judges? Because people struggle, non-attorneys struggle with why it seems to them so much of this is unevenly applied throughout the various departments.
Well, it's not just non-attorneys that struggle. Attorneys struggle as well.
Yeah.
With I mean, judges are humans too, and they're going to come to the bench with kind of their own thoughts and opinions on issues. And inconsistency is just kind of the nature of what we're of dealing with judges. However, at the end of the day, the law is the law. And while it's hard to compare what one judge would do in one case compared to what another judge would do, because so many cases are so fact specific.
Mhm.
I have so many clients. Well, my friend's case this happened and they had this judge, and I'm like, well, your facts are different. So while potentially that could occur, I will say for the most part, the judges have a unified approach, as far as I can tell, as to how to handle the COVID cases. The bar has been, in communication with the courts as far as even just how they're handling hearings
Mhm.
and things of that nature, and letting us know, because that's one issue, is how are we going to even get access to the courts right now? So at the end of the day, the facts are what they are. And as an advocate, I'm there to advocate the facts for my client, as well as advise them of the law and what to expect. So to answer your question in a convoluted way, I would be hopeful that while the discretion does exist, at the end of the day, the standard is what is in the best interest for the children and to keep them safe, and that all judges would apply that same standard.
Yeah, those detailed answers like that are appreciated. The viewership that we have loves when we get into technical details like that. There are a few follow-ups that I had, but first maybe we can jump into close second place as far as the questions that we're getting here. The stimulus checks, and there's sort of two different prongs on this one. I guess some people are curious about why their stimulus check is being intercepted because they owe child support arrearages, and then other people are curious about stimulus checks being deposited into their ex's account and not getting any of those monies. I'm sure you have a lot to say about this. Definitely go all out with it.
Sure, absolutely. I'm getting questions across the board on this issue. So, first and foremost, in regards to your ex's stimulus check, let's start there. I just had this question come up the other day. Hey, I'm getting my ex's stimulus check in my bank account. Can I keep it? No, it is their money. You are divorced, but a lot of times in recent divorces they filed jointly last year, and that's what the IRS has on file.
Mhm.
And what I'm talking about, however, is the $1,200 that you would receive as a person, as an adult. I'm not talking about the money that the parents would be receiving for children. That I believe is separate. So first and foremost, if you get your ex's stimulus check, give it to them. I'm currently in the process of trying to get one back for my clients where the ex got their stimulus check. In regards to the children's money that you would be receiving, I recently did a blog post about this on my website at www.adenlaw.net. And in my blog post, you'll see it says, I don't know what the answer is, but here's my opinion. I have yet to see a decision on this issue. My opinion of this is as follows, and it's really, to me, just applying logic. If the parties are not married, but they share a child or children, and regardless if they share joint custody or one parent has primary and the other parent pays child support, if that parent is current on their child support obligations, then that amount should be split. Both parties are providing for and caring for the children. One is the primary parent, and the other one also on their custodial time or their visitation, but also in the form of paying child support. The reason that child support or the arrears is an issue, or your question in regards to those checks being intercepted, if there's an open district attorney's case where we call them the cases here, where there's an order in place through the district attorney's office, and they're either doing a garnishment, or if you pay through Skidoo, you know what that means. If you're paying through Skidoo,
Mhm.
if you have arrears, they're going to take that check just like any other tax refund at any other tax year. They'll take that money and apply it towards your arrears. But that doesn't exist in all cases. Sometimes there's arrears owed, but there isn't an open district attorney's case. My opinion is, in those cases, if you owe those arrears, that money that you would receive for that child should go to the other parent and be applied to those arrears. So that's how people would see that check being intercepted. But at the end of the day, what I want to say on this issue, and kind of overall in regards to the COVID, because we were talking about custody a little bit, is be a human.
Mhm.
Treat your co-parent with respect. We are all going through a tough time. and everybody's stressed. Now is the time to really step up and be a good co-parent and communicate with them and be reasonable when it comes to these stimulus checks and things of that nature. Even in regards to co-parenting and back to even doing the, talking about exchanges, like put your children first. Your children are watching you and they hear what you're saying and how you're treating your other co-parent. So really now's the time to be a human.
Yeah, I strongly agree. And that's the perspective of most of the questions that we're getting. The concern is that there's exploitation of the pandemic and it's not really sincere issues that are being brought to the attention of the courts or even to the attorneys. So one of the things that you mentioned was the parents that are financially providing for the children are entitled to split that amount. And I do actually get questions, these are prior to the pandemic, but a lot of people sort of had the idea that if the child resides with me most of the time, I get all of the tax monies and I get to claim the children. Does your logic sort of extend to splitting the use of, I guess, the child dependent claim on the tax forms, regardless of who has primary physical custody? And I'm also curious, and I don't want to blindside you with this, to what extent do you use IRS Form 8332, if you use it at all? And I haven't prompted you with this one ahead of time. It just kind of popped out as a possible thing you could answer.
Sure. So 99.9% of the time, regardless of the custodial situation, meaning either if they're sharing joint or one parent has primary, the dependent tax exemption is going to be shared between the parties. In a joint custodial situation, it's easy. It's pretty standard. There is no primary parent concept that exists in Nevada. Physical custody is defined based upon timeshare. Both parents, regardless of timeshare, are viewed to be equal parents. And that really goes into the joint legal custody aspects, that even if one parent only has one weekend a month, which would be a really limited visitation schedule, they still have equal rights to have access to information about their children and have an input and a say where they go to school and what medical treatment they get, things of that nature. So when it comes to the tax exemption, it's treated the same. The only time where I've seen one parent be able to claim the child or children every year is if it's agreed upon. However, the caveat that we do often put in orders is if one parent has primary, or even if they have joint, if the other parent is paying child support, if they want to claim the children on their tax years, they have to be current on their child support. That's not really founded in law or even IRS code. That's hey, if you want to be able to get the financial benefit of claiming the child or children on your tax returns, you need to be current on your child support. As far as the form that you speak of, we don't incorporate or use any IRS forms into our decrees. I don't deal with the federal government in that regard. My advice to my clients is, hey, federal government always trumps. A lot of people try to use hey, I'm head of household, so I get to claim them every year and go around the decree. The IRS does not care what your decree says or what your custody order says. The IRS will take somebody's tax return regardless of what the decree says. It's a federal versus state issue. So if somebody doesn't comply, and I've litigated this issue multiple times, and they claim a child when they're not supposed to, the IRS doesn't care. The recourse would be to file in your divorce or custody case for enforcement of your order and contempt, and seeking the other party to be held in contempt for violating that court order. And then the judge would then, if they find in your favor that the other party did do something wrong and violated the terms of the decree by claiming the child or children when they shouldn't have, will rectify it, either allowing you to then claim the children 2 years in a row, award you attorney's fees possibly, something of that nature. So the IRS and the state governments do not talk.
So one more follow-up before I go into the last question. You mentioned contempt of court, and we do get some questions, mainly what it seems non-attorneys struggle with is the fact that they can't use contempt relief when somebody's doing things that are morally or ethically harmful or wrong. I'm sure you see this a lot where there has to be a violation of the court order. I guess go ahead and elaborate a little bit on why contempt principles work that way. And I don't know what, if any, other sort of relief you have for a client who has an ex who is maybe doing things that are wrong but aren't necessarily in violation of court order. And you go ahead and go into that a little bit, and then we'll go into our final question.
Sure. Contempt is tough. And get questions all the time. Well, he's doing this or she's doing that, and that's not right. And at the end of the day, when it comes to contempt always has to be based upon the words of the order, and it has to be clear and unambiguous if you want to get a finding of contempt. What does contempt mean? Contempt is in the civil context, mostly what we see in family court, because there's also criminal contempt, which sometimes does sneak its way into family court. And I'll explain the difference. But civil contempt is to force compliance. So anytime I'm filing a motion for order to show cause, which is what you would need to file to seek somebody to be held in contempt, is you're asking for them to come to court and explain why they're not complying with the terms of the decree. And the judge's ability to force their compliance consists of sanctioning them, ordering attorney's fees, or potentially, in extreme cases, incarceration. But the point there is to force compliance. It's not to punish. So civil contempt is always, hey, you're not doing what you're supposed to be doing. Now you need to do it. And if you don't do it, I'm going to sanction you or throw you in jail until you do what you're supposed to do. Criminal contempt is to punish. And it's a different burden. It's a different whole area of the law. And it's hard to get, especially in the family law context. But in extreme cases, you can get criminal contempt. Criminal contempt, the ones that I have seen, is perjury. If you lie to a judge, expect to be thrown in jail. Things of that nature. But not communicate, not allowing the other parent to have phone calls. I just had this come up recently. You're preventing the phone calls. The judge would say, stop it and start complying. And if you do it again, I'm going to sanction you or I'll throw you in jail or things of that nature. Again, back to your question, it has to be within the four corners of that document and it has to be clear and unambiguous, which is why it's so important that your decrees and orders are drafted in a certain way.
Right.
And so that you can enforce them. Now, while the biggest one that I think answers to your question is a non-disparagement clause. All decrees that I have have a non-disparagement clause that says, hey, you can't talk bad about the other parent in front of the children. How in the world am I supposed to enforce that unless I have a secret recording device with the children in that parent's home, which you shouldn't do. Don't do that. That's not a recommendation to do that. I have an evidentiary issue when it comes to enforcing those kind of nebulous terms of a court order, like a non-disparagement clause, or even those moral and ethical things that you should or should not be doing. What I tell my clients is this isn't an issue of contempt. This is an issue of modification. If the other parent is doing things that is harming the children or harming your relationship with the children, or that is ethically or morally wrong in your opinion, then let's look at how that applies to the best interest factors in regards to custody, and possibly we're looking at a custody modification to then minimize the child's exposure to that behavior. But even then, at the end of the day, they're mom or dad, and they have a constitutional right to have custodial time with their children in those, except for in those rare circumstances where they really truly are a danger.
Wow.
Human beings aren't perfect. Parents aren't perfect. And the biggest advice I can give to my clients is you can only control your behavior and be there for your children. You can't control the other parent's behavior, and unless it's impacting your children negatively, you're probably just going to have to deal with it.
It's you sound like you're really passionate about what you do, and it's clear that you're a wealth of knowledge. There's so many tangents that we could go off on, but I'm going to stay in scope, and I'll go into the final question. So we have the Honorable Bryce Duckworth in District 8 and the Honorable Bridget Robb in District 2, which is where you're situated, communicating with the media a little bit about domestic violence TPOs and how people can go and get them online or by telephone. Would you care to elaborate a little bit on how, is your office getting any kind of benefit from that? Do you think that's assisting through the pandemic, and to what extent? Do you think to what extent do you think there's an increase or no change at all with domestic violence TPO filings?
So domestic violence is tough. We've seen a 60% increase, I believe, here in Washington County based upon reports. However, the problem that I'm seeing is a lack of resources as far as what if you're stuck in a domestic violence situation, but where do you go?
Right.
If you need to leave. Or on the other side, what if you're able to go get a protection order? And I'll give my 2 cents on the validity of some protection orders. Where is the other party supposed to go? if they're removed from their home and served with a protection order. People are kind of stuck where they are, but not necessarily. I mean, essential businesses are still including, being able to rent an apartment or go and find a new home and things of that nature. So there are resources, and I know the shelters are still operating. As far as the online access, I've heard mixed reviews. I mean, it's some people just don't have the capability to do that. Where with the self-help center now being closed and people don't have access to be able to go into the courthouse and sit there in real time and fill it out even electronically there, is I think is hurtful to some people. However, I know that the shelters have really stepped up to, even if you're not a part of the shelter, that you can go there and you can fill it out and do it online through them. Us as attorneys are also now more empowered to be able to fill them out through for our clients, which we really weren't able to do before. The party always had to file the protection order on their own, so that's been helpful. Uh, it's scary times out there though, and my heart just goes out to, on one side, all of those people that really do need protection orders. However, unfortunately, I have also seen an increase in what we always see, which I think are invalid protection orders, or people using them as a tool in a divorce or custody case. That frankly infuriates me. There are really, truly people out there who are in dangerous situations that need the court there to help them. Do not use a protection order as a tool to try to gain custody of your kids, because if the opposing party comes to me, I'm not going to stand for
Mm-hmm.
it. It's not okay. It's not okay. Don't make stuff up. If you really truly need protection, then seek a protection order and contact the
Mm-hmm.
police. If you're fighting and you're just mad at each other, don't go file a protection order. There's so many people out there right now that really truly need them.
Yeah.
Just I get frustrated with that because I see it so often, and I'm really passionate about both sides of that issue.
Right. I've always said people get upset when somebody who's a victim of domestic violence isn't believed. And I've always said, have you ever taken a step back and thought, why don't people believe them sometimes? It's not necessarily the fault of that particular person, but there's so much deception floating around. I mean, can you really blame people? It's not just that just people automatically don't believe people who claim they're a victim. It's that there is this serious problem in society right now with sorting out the liars, and the judges on the front line have to deal with the reality of that. And it's not always, there's not always a PC approach to this kind of problem, because you create something like that, and then sometimes I also wonder if they do as much damage as the perpetrators themselves, because the deceit is also in a way something that protects other perpetrators, because they can claim, no, I've never done these things. It makes it so murky. And I think you're right. Absolutely, it does infuriate me. So I think we can wrap it up. I really appreciate your time. Thank you so much for coming on, and hopefully we'll see you again sometime.
Yes, thank you so much for having me. This was a lot of fun.